Good morning. I'm Sandy Frank, President of the League of Women Voters of Lee County. I'd like to welcome you this morning and to thank you for attending this educational event, Fundamental Rights and Citizen Initiatives. This is hosted by the League of Women Voters of Lee County, Florida Right to Clean Water, and Reset. It's even more timely today than it was as of yesterday, since Governor DeSantis late last night signed HB 1205 with new requirements for petition gathering and citizen initiatives. Before we start, a couple housekeeping things. Following the presentations, we will have opportunities for participant comments and questions. For those on Zoom, we ask that during the presentations you stay on mute and put your comments and questions in the chat. For those in person, we have index cards in each row for questions, and we will be collecting them. You can raise your hand with the card in your hand, and we will pick it up. A little bit about the League of Women Voters. We started in 1920, Lee County in 1949. We work to empower voters and defend democracy as a nonpartisan organization through education and advocacy. Our initiatives include voter registration and engagement, community and voter education, including we hold educational events such as the event today to increase understanding of public policy issues and to engage citizens in the decisions that impact their lives. Just a note, our next event will be back here at the Collaboratory on October 4th, and that will be an update on the transition of Lee Health from public to private. So you can mark your calendars for that. We also influence public policy to address important Lee County, Florida, and U.S. issues. We have strong and targeted advocacy related to league positions that are developed through study and member consensus. We develop partnerships and coalitions with allies who share our goals and want to work with us. And we have an advocacy program developed by our members and implemented by our league leaders, committees, and members related to this year affordable housing, environment, education, health, gun violence prevention, among others. Looking ahead, the League of Women Voters has a campaign for making democracy work, and they have just started an initiative launched May 1st called Unite and Rise 8.5, a campaign to defend democracy by engaging 8.5 million voters through advocacy, mobilization, civic education, and community engagement. We will be participating in that, and I hope that all of you here today will be as well. Also, many of you who are on our email distribution list, and those who aren't, you can sign up. You've gotten information about the SAVE Act that would require documentary proof of citizenship for persons to register and re-register to vote, and has other obstacles. So we're asking that everyone contact their Senate to work against that bill. And finally, in Lee County, we plan to support single-member districts for the Board of County Commissioners. That bill was passed by the legislature. I don't believe it's been signed by the governor yet, but we do plan to prepare by educating voters for the November 2026 referendum on this issue, which will be very important for Lee County to have single-member districts. At this time, it is my honor to introduce our moderator, Gary Robbins. Since I met Gary 8 to 10 years ago, and I have always experienced his commitment to the environment and his calm presence. When I reviewed his background for this event, I realized that this is a reflection of his life experiences and beliefs. I'd like to mention a few of his current and recent accomplishments or positions. He was a co-founder of Pachamama Alliance Community and is an organizer of the Pachamama Elders Council. He's a co-founder of Southwest Florida Climate Action Fund, co-founder of Southwest Florida Reset, founding member of Florida Rights of Nature, and he's also vice president of the Lee County Rights of Nature and is a founding member of Florida Right to Clean Water. He has his whole life worked to empower people to be informed enough to make major life decisions while being sensitive to the interests of those within their circle of family and friends, with a further goal of growing the circle of we and us. So I would like to introduce Gary Robbins, who will then, I'm turning this over to you in good hands. Thank you, Gary.
Thank you, Sandy. It's good to see you, all of you here today. We've got really important work to be doing, and I'm glad that you are here to be part of the team to help things really move forward. And thanks to Sandy and to the League for all of the work that you have done since my mom was 16 years old. And I really appreciate what you are doing in our community to build the stronger community that we need. As you can see from the banner for reset, we want to reset our priorities. And as president of Southwest Florida Reset Center, we want to point to the prime path forward being from the heart by restoring Earth as our sacred ecological trust, which we do primarily by promoting the inherent worth and dignity of every individual, the values of justice, equity, and compassion in all our relations, and with respect for the interdependent web of all existence of which we are part. In short, we must turn our national inclination from othering to a true practice of belonging and inclusion, enlarging the circle, as Sandy said, of we and us. And for just a few moments, I'd like you to close your eyes, if you're comfortable doing that, and think of all of the individuals in your life that you are in relationship with, the groups that you belong to, and those that you interact with on a regular basis. Just take 15 seconds, 20 seconds, think of those things, those people, those groups. I'm sure that there are many wonderful people that have just crossed your mind. These are your and our support system and members of the community of support. It is our sense of community that will buoy us up when we are down, and it is we who can support those who share our values. This is not new to us, but we really are the incredible ancestors that our future generations will look back at and wonder how in the heck we were able to actually save our democracy under such dire circumstances and to make it better, make it what we hoped that it would be, and how we together as an active community were able to restore Earth as our sacred ecological trust. Now, I'm looking at a sheet that I'm missing, so let me just, here we go. As Sandy said, the format for the program is that we have two speakers today, and each of our speakers will have approximately 40 minutes to make a presentation and for questions and answers. And for those of you here in person, please pass the cards down the length of the table. And as questions come to your mind as presenters are making comments, please write the questions down and pass them back down to this end of the table so that we can collect them and they can be in our hands when the presentation is done so we can get right to the presentation and to the questions immediately. And if you would, please put your name on the card just so we can address it directly to you as well as to the others. And for those of you attending on Zoom, as Sandy said, use the chat function, please, for the questions. And do that as they arise to you. And we're trying to do this to be as clear as possible regarding the issue you wish to be spoken to. It is our goal to keep to the timeline that we have outlined for our meeting today. So we will be completing the meeting by 11 o'clock. And this is to honor the fact that some of us undoubtedly have other commitments following this meeting. Now, our first speaker is Joseph Bonasia. Many of you know Joe in many different ways. He's been around this community for some time now and has had leadership positions in many different environmental organizations. And he's chair, as you know, from the writing chair of Florida Rights of Nature Network, FRON, and Southwest Florida Regional Director of Florida Right to Clean Water. And he's also a member of Protect Our Wetlands, Cape Coral. And he writes about constitutional environmental rights and climate change. And if you have not gone to the Invading Sea to check out his articles as on the announcement of the meeting, I invite you to do so because his articles are beautifully written. They're a testament to his many years as a high school classroom teacher, helping young people become proficient in the use of English language, and you will see that in his articles, and as well as his devotion to being in nature and the many, many miles of hiking on the Appalachian Trail and caring for the wildlife in Cape Coral. He's a founding member of Southwest Florida Reset Center and has served on our board from the beginning. He's a wonderful colleague and a trusted friend. Please welcome Joe Bonasia.
And if I can just remind everybody, during the Q&A session, if you have a question, raise your hand and wait for the mic to come to you. That way, those on the Zoom can actually hear the question that you have. Okay.
Thank you. Good morning. Pleasure to be here. For a moment, let's presume that you have the great fortune of sharing a lake with your neighbor. Here is your property. Here is his or her property. The lake's right in the middle. All the water that your family drinks comes from that lake. You wash with it, you cook with it. Your kids are playing in the lake water every single day. You and your spouse like to sit down with a cup of coffee on the porch, just looking at the water in the morning and in the evening. During the day, you love to watch and listen to the wildlife that the lake attracts and sustains. It gratifies you deeply that you are able to give this gift of living so closely to the lake and nature to your children. Furthermore, the lake provides you with your income because you love to fish and you sell the fish that you catch. Then one day, your neighbor starts a business operation that pollutes the water of the lake. Suddenly, you get sick. Your spouse gets sick. Because they are smaller and more vulnerable, your children get sick. One of them is so sick that he cannot go to school for 18 months. Furthermore, your income plummets as the fish populations in the polluted water plummet. The quality of your family's life decreases as pollution levels rise. Shouldn't there be a law that protects your family's vital interests, your health, your prosperity, the quality of your lives, by protecting the quality of that lake water? Shouldn't there be such a law? I can't imagine that anybody would say no. Let's say there is a law. Let's say there are lots of laws to protect water quality, but your government isn't enforcing them. Shouldn't there be a law that you can use to hold your government accountable? a law that you can use to compel it to enforce its own laws. Should there be such a law? Again, I can't imagine anyone saying no. One more thing. Let's say that your neighbor is contributing very, very generously to the campaign coffers of people running for political office, lawmakers, and they in turn turn around and make laws that benefit your neighbor's commercial interests at the expense of your family's health, economic prosperity, and quality of life. Shouldn't there be a law that you can use to protect your family's interests against this type of political corruption? Of course. One more thing. What if your government doesn't want you to have such a law? Shouldn't there be a law? Shouldn't there be a democratic mechanism that you can use to create such a law even when your government doesn't want you to have it? This is what we're going to be talking about today. Because in the first three cases having to do with water quality, the law we need is the proposed Right to Clean and Healthy Waters constitutional amendment. And in the second case, where we need a law to create such a law, we're talking about a citizen initiative. Right now, Florida Right to Clean Water is in the midst of a citizen initiative. Our goal is to collect 900,000 signed petitions to qualify for the 2026 ballot. As noted by Sandy just yesterday, a new law was passed that basically takes an iron spike and runs it right through the heart of citizen initiative efforts here in Florida. I'm going to spend a little bit of time talking about Right to Clean Water. Our second speaker from the ACLU, Mr. Skhir, is going to be talking with authority about citizen initiatives in Florida and the implications of the new law. So let's talk about Right to Clean Water. First, do you happen to share a lake with your neighbor? The same way you share aquifers with your neighbor, and Lake Caloosahatchee River and springs and wetlands and such. What condition are they in Florida? I've been talking about this for a couple of years. On a scale of 1 to 5, 1 being terrible, 5 being great, what condition are our waters in? 2. Okay. Can we go to the... So let me just share some information with you. We're just going to skip down a little bit. Just some rather jaw-dropping facts. So everybody's got the same foundation of information about our waters. We got 50,000 tons of legacy phosphorus sitting in the bottom of Lake Okeechobee. Water gets released, and we end up with blue-green algae blooms down here in Fort Myers and Cape Coral. Cyanobacteria makes people sick, threatens you even with long-term neurodegenerative diseases. Red tides have exploded in the last 30 years here in Florida. We've had 200 months of red tide in Florida since 1994. In the previous 116 years, I guess since when they started taking records, there were only 64 months. Red tide is a natural phenomena, but not at this frequency, not at this intensity, and not at the duration that they last now. And of course, everyone remembers back in 2018, 2019, we had tens of tons of dead sea life that had to be hauled away from our shores because of red tide, and that's just a fraction of the death toll out off the shore. Fecal bacteria counts. There are nearly 1 million acres of estuaries and 9,000 miles of rivers and streams in Florida contaminated with fecal bacteria, and I learned that from Calusa Waterkeeper some time ago. Things haven't gotten better. Calusa Waterkeeper also told me that here in Lee County, fecal bacteria levels in some of our rivers are through the roof, sometimes 10 times higher than what the health codes call for. Everybody knows that we've had a historic loss of manatees. Why? Because our seagrass beds are on the brink of a death spiral. Recently, Tampa Bay Times did a report said that over the last 10 years, Florida has lost 89,000 acres of seagrass in Florida. It's a keystone species. When it goes, other species go with it. Up north, northern Florida, we have 1,000 springs. 800 of them are polluted. No state has more acres of polluted lake water than Florida. No state has lost more acres of wetlands than Florida. 9.3 million acres. So, what do we in Florida here do about it? Some of you, I'm sure, will remember former Commissioner Ray Judah, and he was a super knowledgeable man. His environmental credentials are stellar. About 8 months ago, he wrote an op-ed. It was in the local papers, and it reminded everybody about that common definition of insanity, doing the same thing over and over and expecting a different result. He said, well, we've been trying to elect the right people into office for decades, hoping they're going to do right by our waters, and that hasn't happened. So, back in 2020, folks in Orange County took a different tact. They amended their county charter, giving waterways rights, right to exist, flow, to be free of pollution, and they gave every Orange County citizen a right to clean water. And what happened? Well, it got voted on. 89% of Orange County voters passed it. 9 out of 10 voters. When do 9 out of 10 Americans agree about anything? They agreed about this. But between the time that it got on the ballot and it was voted on, our legislature stepped in. And they took those rights away by preempting the authority of local governments to pass laws granting any rights to nature, but also granting citizens any rights to any aspect of the natural world. They couldn't make it any clearer. Our lawmakers do not want us to have a right to clean air, a healthy climate, or clean and healthy waters. It was this preemption that a Florida appellate court referenced back in December when it affirmed that in Florida, there is nothing in general law or in our Constitution that gives Floridians a right to clean water. So let's go back a little bit. That preemption told us two things. Number one, they must really fear a rights-based approach to environmental protection. And two, we had to go over their heads. Can we go back one more? I want to tell you about two very important court cases that tell us why a right to clean and healthy waters constitutional amendment is the law that we need in Florida, the law that would answer those first three situations that I started with. In Pennsylvania, big fracking state, back in 2011, their legislature passed a notorious law called Act 13. It basically compelled local governments to allow fracking operations anywhere anyone wanted them. If your neighbor wanted to start a fracking operation on his or her property, no matter what the zoning laws were, the municipality couldn't stop it. Within 300 feet of an elementary school, a wildlife sanctuary. It even came with a gag rule. Doctors were not allowed to talk publicly about the health impacts that they were seeing in their patients. And there was a very famous case at the time, and this woman testified as part of this court case. She was a single mom. Her neighbor started a fracking operation. He had a fracking pond. She got sick. Her daughter got sick. her son got so sick that he was home for 18 months from school. Their farm animals died. She had to get rid of the farm, etc. So what happened here? Much to the credit of a handful of these townships, they filed legal action against their state. They said that Act 13, this pro-fracking legislation, which, by the way, was written by the fracking industry, and the governor that year accepted $1.7 million worth in campaign contributions. They said that this law was unconstitutional, and it went all the way up to their Pennsylvania Supreme Court, a conservative Supreme Court. And that court agreed with them. It did find key provisions of Act 13 unconstitutional because back in 1972, Pennsylvania citizens decided it was time that they had constitutional environmental rights. And they voted to amend their constitution with this amendment, that people have the right to clean air, pure water, and the preservation of the natural, scenic, historic, and aesthetic values of the environment. What I love so much about this is that the Chief Justice who wrote the opinion took 162 pages to do so. He detailed the history of environmental degradation in Florida, timber industry, coal industry, fracking industry, because he wanted to make this point. It is not a historic accident that the Pennsylvania Constitution now places citizens' environmental rights on par with their political rights. Those folks knew what they were doing. The political rights that the Chief Justice is referring to are those fundamental American rights that we hear about, read about every single day, and which are in the news now perhaps more than ever. Those that are most commonly known in the First and Second Amendments of the Bill of Rights. Right to free speech, freedom of religion, right to bear arms, the right of assembly. And in case you don't know, the right to petition one's government for the redress of grievances. That's right there in the Bill of Rights. These people understood that environmental rights are just as essential to their well-being and their liberties as all those other fundamental rights. Constitutions provide the strongest formal law and the highest level of protections. That is why we need to have a right to clean and healthy waters constitutional amendment in Florida. It is above the governor. It is above the legislature. It's the law of the land. One more example. I hope you know about this one. This was much more recent, happened within the last year or so in Montana. They had a law on their books that said their lawmakers could not, not their lawmakers, their Department of Environmental Protection could not consider greenhouse gas emissions when deciding whether or not to provide a permit for a fossil fuel operation in Montana. So just think about that. The mission of the Department of Environmental Protection is to protect the environment, but here they were being told, except when it comes to climate. Well, 16 young Montanans took exception to this, and they sued their government. They said this fossil fuel-friendly law is unconstitutional. And that is because back in 1971, 72, Montanans decided it was time. They needed constitutional environmental rights. They amended their state constitution. Every Montanan has a right to a healthy environment. And in this particular case, they proved that they're already being impacted by climate change. The court agreed with them. There have been a number of climate cases, as you probably know, youth climate cases. This is the only one so far that has been successful, and that is because it is based on that constitutional right that they have. Another example that constitutional environmental rights are at the apex of our environmental law system. We do not have that right here in Florida. What does our Constitution say? It shall be the policy of the state to conserve and protect its natural resources and scenic beauty. That is not an explicit declaration of a right. It's a policy. Policies come and go. You have one administration here that appreciates the absolute value of a clean and healthy environment, and they do their best to protect it. Administrations leave. Somebody else comes in, and those policies are gone. Our waters, a healthy environment is too important to fall victim to changing administrations and such. Adequate provision shall be made by law for the abatement of air and water pollution. Has adequate provision been made? No. Our waters are terribly polluted. Once again, because I'm looking at folks from Calusa Waterkeeper, our waters have declined over the years. They haven't gotten better. I remember explicitly Waterkeeper John Cassani in 2020 saying that the Clean Waterways Act was just going to put us 5 years behind schedule. And he was right. So, I'm very quickly going to tell you what our amendment does, and then I'll open this up for questions. So very quickly, it's got a nice paragraph to start with. If you read the full text of the amendment, it's called Purpose. What's the purpose of this? Clean and healthy waters promote important public interests, including health, prosperity, and quality of life. It goes through the trouble of listing them. Clean drinking water from clean and healthy aquifers, scenic beauty and recreational activities. It's so much an aspect of quality of life down here. It's why many of us are here. We love to be on the water, look at the water, in the water, etc. Fishing, harvesting, way of life, a $15 billion industry in Florida. I believe everybody here in Florida, or nearly everybody, absolutely loves our wildlife. Look, there's a dolphin, and 20 heads turn. Well, they need clean and healthy waters. I certainly have spoken to fishermen who have told me that the fish populations now are not what they used to be, and that the wildlife populations are not what they used to be. Aquatic ecosystem services, including water filtration and risk mitigation for droughts and floods. We're talking about a lot of storm protection here. In case you don't know, I come from Cape Coral. Cape Coral is one of the 9 cities in the nation most at risk from future storms. So I can't imagine that Fort Myers is much behind. Economic interest and business opportunities. Do I provide a little chart here? Oh, I didn't have the chart. Well, our tourist industry, our property values in the billions of dollars depends on clean and healthy waters. I could provide the statistics from an economic study by the Conservancy and SCCF and Captains for Clean Water later. So the purpose of this amendment is to advance these public interests by creating an enforceable fundamental right to clean and healthy waters, authorizing a person to sue for equitable relief when a state executive agency, by action or inaction, allows harm or threat of harm to Florida waters. It enables us to sue our state agencies when they harm or threaten harm by action or inaction. They threaten harm by action. Here you go. Here is a permit to go build in those wetlands over there. By inaction, well, we're back to the many, many water quality laws in Florida that aren't being enforced. Make no mistake, water pollution exists in Florida because the state is allowing it in one way or another. So, very easily, there are 2 main points to the amendment. and this is not in legal terms, very down to earth terms. It says this: if our agencies are going to allow harm to our waters, they must have a compelling state interest for doing so. In other words, a damn good reason. Something that somehow is as important or more important to the welfare of Floridians than clean and healthy waters. That's why we went through that list of all those things that are so essential to us. How many things can rise to that level here in Florida that are going to be more important to us than clean and healthy waters? And number two, in those few cases when there is a compelling state interest, then our agencies have to make sure that the harm that they do allow is as little as is necessary to fulfill that compelling state interest. Let me give you a very concrete example. Oh, and if they don't, with the fundamental right, we can take them to court and hold them accountable. And the courts can turn around and tell them basically, do your job. The people have this fundamental right. Your job is to protect it. So, photo from Calusa Waterkeeper. This goes back to last spring. Water releases from Lake Okeechobee. The brown chocolatey looking stuff is the water coming down from Lake Okeechobee. With this amendment, we could file a lawsuit holding the agencies accountable and saying, no more water releases. You're harming our waters down here. You're making us sick. The agencies would have to make their case. And in this instance, they could, because we cannot have Lake Okeechobee overflowing. You're going to put communities at risk. So there's a compelling interest to let the water out. However, it's not just the water coming out, it's the quality of the water. There are 32 water basins around Lake Okeechobee that currently are not meeting water quality standards. And sometimes, in one case, 19 times higher than what law allows. What is the compelling state interest for permitting such egregious levels of pollution? I can't imagine any agency would be able to defend that. What would happen? The court would not say, all right, all you Floridians who brought this lawsuit, here's $30 million, you won. Nope, that's not what happens. What the court does is turn around, go to those agencies and say, you must stop the continued harm. We know our government is spending billions of taxpayer dollars on big projects to clean up Lake O water after it's polluted. Please raise your hand when you can recall a time when they spoke about stopping the pollution at the source. This law would enable us to do that. Just one more example, because it's so important here in Lee County. Our wetlands are under attack. Pressure to develop. We know 1,000 people are moving to Florida every day, etc. 2 years ago, Supreme Court case, Sackett versus the EPA, they changed the definition of waters of the United States, and they opened up millions of acres of wetlands to potential development and harm. And the current administration is doing its best to roll back other environmental regulations, as you know. Even as federal protections decrease, diminish, constitutional environmental rights can provide the protections we need, because in such matters of substance, the state constitutional law prevails. Right now in Lee County, excuse me, not in Lee County, it is in Lee County, in Cape Coral, there's a developer who wants to build, it's his property. He's got about 400 acres of wetlands, and he's got about 93 acres of uplands there. They're about 8 inches up. And he wants to build another big development like the Weston, Tarpon Point. Well, my backyard butts up against his wetlands, as does everybody on my street. When we moved down, we were told, don't worry, nobody's ever going to develop there. Well, now there's a real threat of development, And we are doing our best to make the case that this is unsound. Maybe back in the 1950s when they bought the land, there was expectation of development. But since then, we don't have a hell of a lot of space left in Lee County. And I wish I had slides again from Colusa Waterkeeper that shows you just how little we have left. And so this law can finally draw a line and say, time to build somewhere else. Not in wetlands anymore, not in Florida. Very quickly, and there's Mr. Robbins. The biggest concern of people, isn't this law going to cause a proliferation of lawsuits? No, that's not going to happen. Why is that? Because it hasn't happened in Pennsylvania, it hasn't happened in Montana, it hasn't happened in New York. I don't know where. I think it's an honest concern of people. Others, perhaps it's a bit of fear-mongering. It's not going to happen. What else? Wouldn't it be a field day for lawyers? They're going to see big money signs. Let's make a lot of lawsuits that we don't need. No, because as I mentioned, it's not about damages. They're about remedies and restoration of our waters. Nobody walks away with a pot of gold. What happens is the agencies have to do their job. The legislature will undermine this amendment. There is some cynicism out there. Citizens have passed amendments before, only to see the legislature do its best to undermine the intent, the effectiveness of the law. Well, some of Florida's best environmental lawyers have written and helped revise this to protect it as much as possible against legislative action. Don't we already have enough laws to protect our water? This one gets me. If we had enough laws, our waters wouldn't be in the situation we're in. We need another law. We need the constitutional right to clean and healthy waters. So, last night, here we go. Boom, boom, boom. As I said, we need 900,000 signed petitions by the end of this year. How many do we have right now? We're somewhere around 55,000. Things have been ticking up of late as the public seems to be more concerned about the direction that things are going. But, as Sandy noted, HB 1205 is now law. Last night I got a text from our attorney that said the aspect of that law that applies to our purely volunteer effort takes effect on July 1st. So we are going to continue to collect petitions as vigorously as we can until then. What else has to happen? There will be lawsuits contesting this new law. There's a very good chance that Right to Clean Water is going to be a plaintiff in one of these laws because we contend that it violates our First Amendment rights, among which is the right to petition one's government for the redress of grievances, and we've got grievances when it comes to the state of our waters. So Mr. Skhir will go into a lot more depth to talk about 1205, the history of citizen initiatives in Florida. But for a few minutes, I'll take questions about our amendment, if there are some. Am I on schedule here time-wise? Okay.
Thank you, Joe. That was awesome. So one of the questions I have is, how do I find out if my petition has been accepted? Because the last time around I signed and apparently it wasn't accepted. So is there a way that, can I call down to the supervisor of elections office and?
That's the quickest way to do it.
Is that the quickest way?
Yep.
So it's really on sort of, the person who has signed the petition to maybe have that extra step and just verify that indeed your local supervisor of elections accepted your signature and everything is all good to go.
That would be the easiest thing.
Okay, thank you so much.
Yep.
Have any written questions?
One of the things I haven't heard discussed, which both underscores and overwhelms the issue we're facing, is the lack of water in the center part of the state. The developers have already been approved by zoning commissions and commissioners to start development. And according to my cousin who lives there, they have not done any water studies. He has a 400-foot well that went dry. Nestle's is pumping water out at ridiculous amounts, and I don't understand why there hasn't been a lawsuit, because that is going to create the most harm, not having any water.
So there was a lawsuit similar to this. It had to do with Ginny Springs. It took place a couple of years ago. Initially, it did involve Nestle. There's a water bottling plant, and they wanted, they've been pumping, and they wanted a permit to pump about 1 million gallons a day out of Ginny Springs and the Ginny Springs aquifer. There was a lawsuit. Florida Springs Council took them in the court. 19,000 public comments were made, the vast majority opposing this permit. What happened? The permit ultimately was issued. If we had our amendment, all we'd have to do is establish that that water bottling plant is harmful to the waters, and we'd be able to protect them.
We have one question here. What is the biggest obstacle to getting enough signatures? And we need to answer it quickly because we need to get on with the rest of the program.
The biggest obstacle is that nothing comes close to one person standing in front of another person asking them to sign a petition. If it was as easy as telling people to go to our website, download the petition, fill it out, and mail it in, we would have qualified a long time ago. Unfortunately, a lot of people don't have printers. A lot of people don't have the time to do that. We need more people to be volunteers, to help us out, and be petition gatherers. The more, a small.
I have a question.
Go ahead.
I just want to make, I guess, sort of a comment and a question. I recently heard the director of the Wildlife Corridor effort, and clearly there's overwhelming public, support of that, and the governor knows it, and he goes for it as well because of that. We see in Conservation 2020 in our local area, the kind of vote we had, and you have the Orlando example. It's clear that the public will is in favor of preservation and so forth. The issue is the mechanics of getting that in front of the legislators and making it so compelling that they will take action and revise their attitudes. Because if they thought, and if the public really responded, they would respond. Question is, how do we do it? And apropos of the technology, nowadays in my world, out of finance and capital markets, so forth, everybody's going to things like DocuSign. Is there any way of going electronic and doing petitions?
The legislature will not permit that. Again, we would have qualified. I think there have been several attempts to get that going. In fact, I think there was a bill in the legislature this session, and it did not pass. If we had an absolute uproar like we had last year when the whistleblower blew the business about the parks, well, maybe that would get our legislature to do something. To let you know, there are about 20 other states attempting to do the same thing we're doing, because we're not unique here. I will tell you that we are the only one that has to do this through a citizen initiative, because elsewhere they have faith that their legislatures is still a viable path to constitutional environmental rights. We don't see that in the near future for Florida. And obviously, the legislature doesn't want us having this right. And they don't even want us having the democratic ability to fulfill the people's intent when we know they're not doing what we want them to do. That's the whole point of having a citizen initiative. I'm going to stop talking now and give time to the next speaker.
Okay. Thank you very much, Joe. And to your last point, Joe, I remember at the end of a big environmental conference that we had a year and a half or so ago, there was a gathering of the powers that be after the event, and the scuttlebutt that came from that was that the former director of Department of Environmental Protection said, there is no way we can stand to have this amendment pass. What do you think he's protecting? He's certainly not protecting the environment in the state of Florida. And that's one of the main things I think that happens, is that people get bought in one way or another and get convinced that that is the way. And it's all part of the whole concept of othering. We are other to the legislature. The earth is other to corporations that pollute. We are other in so many ways, in the way that people get treated by our government, and that is something that we need to really address, because that is what has given us some of the worst experiences this country has ever had. Our next speaker is an incredible man, Abdelilah Skhir. Joined the ACLU of Florida as a policy strategist in January of 2021. In his role, he's responsible for analyzing and developing state and local policies, supporting an impactful, nonpartisan policy advocacy program. As a son of immigrants, he brings firsthand knowledge of the direct impacts our voting laws and policies have on immigrant families and communities. And as you know from the other things that were said about him in the invitation, before joining ACLU, he worked in the labor movement, organizing adjunct professors throughout Florida. And prior to that, he worked in several roles at the League of Women Voters of Florida. And I am pleased to tell you that he has an interesting interest. He is an avid professional wrestling fan. He loves Martin Scorsese films. He loves comics, Star Wars, and he does some hiking. And he's from Miami. And so the beach is always important. And one of the more interesting things is he loves to travel the U.S. by train. So fascinating person. And now please welcome Abdelilah Skhir.
Thank you so much, Gary. I really liked you highlighting my, yeah, if anyone ever wants to ask me some wrestling trivia, I will take you up on that, because I can pretty much name every WrestleMania main event for the last 20 years. But aside from that, thanks so much. It's really an honor to be here presenting for you all. As Gary mentioned, you know, I got my start in my
Abdel,
career.
we're trying to get the volume set here. We're having a little bit of a problem
Okay.
hearing you.
Can you hear me now?
Okay.
Is that good?
Yes.
Okay, perfect. I was just saying thanks for inviting me on. It's an honor. You know, as you said, I got my start in my career now 10 years ago at the League of Women Voters of Florida state office, and so it's always a pleasure to collaborate with y'all and really push the ball forward in terms of defending democracy and empowering voters. Because the ACLU very much shares those goals and aspirations. So I'm going to share my screen real quick here. Perfect. All right. If someone could please just give me a thumbs up if you see the title slide there. All right, and I'm going to go ahead, but if you can't see anything, please just let me know. But yes, so I am, as Gary said, my name is Abdelilah Skhir. My pronouns are he, him, and I've been in my role at the ACLU of Florida for 4 years now. And I will be happy to talk to you all about citizen-led amendments in Florida. So I don't like to assume that people know who we are all the time. So just a very brief overview of who the ACLU is. So the American Civil Liberties Union was founded in 1920, much like the League of Women Voters. The Florida affiliate was founded in 1965. And like the League of Women Voters, we are also nonpartisan. We do not endorse or oppose candidates. And our mission is to protect, defend, strengthen, and promote the constitutional rights and liberties that all people in this country are guaranteed by the Constitution and laws of the United States and the state of Florida. We envision a fair and just Florida where all people are free, equal under the law, and able to live with dignity. And so what we'll cover in the next few slides is just a few topics. What is a citizen-led amendment? A few notable examples, and then I'll go through some of the attacks on the process that has happened pretty much over the last few decades, as we'll go over. So, we heard a lot from the fine folks at Clean Water, and, again, I don't like to assume that people have a baseline knowledge of this, so we're just going to go over really quickly what is a citizen-led amendment. So, for decades, everyday Floridians, like you all, have used citizen-led amendments to pass policies that improve the lives of all Floridians. As we'll go over in just a couple seconds, really impactful policies that have affected millions of lives have been directly a result of passing constitutional amendments that were initiated by the people. And why do they do that? Because those are typically issues that our legislature fails or chooses not to address. Our process is already the strictest in the country. It requires almost 1 million signatures and 60% supermajority from voters to pass. So it's extraordinarily hard to pass a constitutional amendment as a citizen-led amendment in Florida. But we've done it time and again, despite the hurdles that have been created throughout the years. So there are 5 ways to amend the Constitution in Florida. Most of the amendments have been referred to by the legislature, and that requires a 3/5 majority of both chambers to approve those. The Constitution Revision Commission meets every 20 years to propose amendments for approval by the voters. The last one was in 2018, and I'm sure many of y'all remember that with I will say ridiculous amendments that were kind of bundled up together. That was unfortunately a process that was hijacked by politics, where previously it had worked pretty well. There was a constitutional convention, which has not been done in Florida as of yet, the Taxation and Budget Reform Commission, and then, as we'll go over now, Citizen Initiative. So just a fun fact, since the current Florida Constitution was ratified in 1968, our Constitution has been amended 146 times. Now, that's nowhere near the most in the country even. I believe Oregon has the most with over 450 amendments to their Constitution. So we're actually pretty far behind. And so here is the section in the Constitution that allows for citizens to propose amendments to the Constitution. Article 11, Section 3 of the Constitution states that the power to propose the revision or amendment of any portion of this Constitution by initiative is reserved to the people. And I bolded that because I like to stress that a lot, especially at the legislature. It's a power that's reserved to the people, not politicians. And, there's a few additional language there, single subject rule and all of that. And there are additional rules that have been put in place throughout the years requiring half of the congressional districts in the state, a certain percentage of those signatures have to come from those congressional districts. And that's based on the presidential election numbers. But Florida is only one of 18 states with a citizen initiative constitutional process. Some states have statutory initiatives, some have both, but Florida is only one of 18 states with this grassroots citizen-led process. And as we'll learn in just a few minutes here, that has been dwindling. That power has been usurped over the years by the legislative branch. But before we do that, let's just get into a few of the notable citizen-led amendments that have passed in Florida. So the very first amendment to citizen initiative to our Constitution was the Sunshine Amendment in 1976. And it created the Sunshine Amendment provided for constitutional guarantees regarding ethics in government and established the Commission on Ethics. And as we'll see in just a couple of seconds, that kind of set the, once that passed, that's when we started seeing a lot of the attacks on this process because the powers that be realized the threat to their power that this process represents. In 2002, Florida voters approved universal pre-kindergarten for Florida families. We were one of the first in the country to offer that. And that's been great for Florida families. I believe it's 95% of brain development happens between the ages of 2 and 5 years old. I could be off on those years, but it's a huge amount of brain development that occurs in those very early childhood years. And we were one of the first in the country to be able to offer free pre-K to families. The minimum wage was raised in 2004. And that's when we saw some additional attacks on this process, and that'll be a running theme here. In 2010, as you all know, as league members, the Fair Districts Amendments passed, which banned partisan gerrymandering, which is when legislators draw districts to favor or disfavor a political party or an incumbent or by race. And those really did provide some groundbreaking protections. Now they're under threat from the judicial branch, but that was, again, something that the vast majority of Florida voters at the time approved of. In 2014, voters approved Land Acquisition Trust Fund to preserve our wildlife. In 2016, Florida voters passed medical cannabis. In 2018, again, y'all were super involved in the Voter Restoration Amendment to allow people with felony convictions the right to vote again. And in 2020, we raised the minimum wage again to $15 an hour. So, as I mentioned, we have seen state interference with direct democracy and with the citizen-led amendment process. And I wanted to, this was an interesting exercise for myself because a lot of folks, when we talk about the attacks on the process, think from the last few years. But in reality, as I said, the Sunshine Amendment back in 1976 kind of kicked it all off. And so I made some notes here. You know, if it's going on a little too long, Gary, feel free to just give me a little nudge. But I did want to just talk about some of the prior attacks on this process. So since voters advanced the very first citizen initiative, which was the Sunshine Amendment in 1976, the legislature has repeatedly put constraints on the process to make it harder and costlier for Floridians to propose a constitutional amendment and to get it on the ballot. So in 1976, after that first amendment passed, the legislature banned collecting signatures within 100 yards of any polling place. In 1977, the legislature required sponsors to pay verification fee of 10 cents per signature or the actual cost of verifying, whichever was less. So unlike candidates who couldn't afford the cost of verifying candidate petitions, initiative sponsors who couldn't afford to pay that could not file what's called an undue burden oath and waive the fee. And that thread of putting limitations on constitutional citizen-led amendments that aren't imposed on candidates is going to be a recurring theme here. So in 1978, which was just a year after the second citizen initiative made the ballot, the legislature required sponsors to register as a political committee and to submit the amendment text and ballot summary to the Secretary of State for approval before obtaining any signatures. After the first two amendments used ruled line petition forms where multiple voters could sign on a form on a single sheet, the secretary required a separate card or sheet of paper for each signature. In 1980, the legislature limited the ballot summary for an amendment to 75 words, while requiring the sponsors to explain the amendment's chief purpose within those 75 words. And as many folks here know, that can be very difficult, especially with things like the single subject rule and trying to avoid being ruled by the Supreme Court as misleading to voters. In 1983, the legislature set a 4-year expiration date on initiative petition signatures. In 1986, the legislature put on the ballot an amendment that mandates automatic Supreme Court review of constitutional amendments, but not amendments that were referred to the ballot by the legislature. Again, in 1990, the legislature passed, but the governor did veto a bill that would have required petition signatures to be witnessed and banning paying petition circulators per signature, which is a big incentive for folks to be getting petition signatures. And they tried to do the same in 1991, but again, the governor vetoed that bill. In 1997, the year after 3 Everglades conservation initiatives appeared on the ballot, the legislature enacted a pretty large law that required sponsors to pay verification fees in advance, required sponsors to file an affidavit with the Division of Elections if they wanted to use paid petition circulators, required sponsors to provide the name and address of each individual who was paid to collect petitions, and a few other things. In the interest of time, I'll move along here. But again, we're seeing into the modern era of creating administrative and legal hurdles, which we'll get into. In 2002, again, after universal pre-K and reduced classroom sizes was approved by voters, the legislature tasked what's known as the Revenue Estimating Conference with writing what's called a fiscal impact statement for every ballot initiative, which would state the amendment's estimated impact on state and local government revenue and costs. In 2005, the legislature moved the deadline for signatures to February 1st. So they moved it up by 5 months, the deadline to get ballot signatures to get it on the ballot. In 2006, the legislature, after the Supreme Court rejected 3 different financial impact statements for being not meeting statutory standards, the legislature changed the law to make it so that the President of the Senate and the Speaker of the House are, quote, the sole judge for the interpretation, implementation, and enforcement of initiatives' financial impact statements. In 2006, the legislature placed Amendment 3 on the ballot that raised the threshold required for amendment passage to 60%, which, as we all know, has played a very large part in the difficulty now in passing an amendment in Florida. In 2007, the legislature required petitions to set forth a voter's address, county, and voter registration number or date of birth to be verified as valid, and allowed voters to revoke their signatures after signing. And I'll note that revocation was repealed in 2011. In 2008, very shortly after Fair Districts now launched their campaign for Fair District amendments, the legislature banned a petition form from being bundled with or attached to any other petition. So you couldn't offer someone, on the same clipboard, 2 different amendments to sign. You have to have totally separate things. And again, this was a response to a grassroots effort that politicians just didn't like, right? So in 2011, after those Fair District amendments were approved, the legislature cut the expiration window for signatures in half, from 4 to 2 years. And they abolished the cheaper method for signature verification which was, the supervisor of election would randomly sample some petitions to verify, and that would be represented, it's basic statistics. You get a random representative sample, and that is a representative of the whole. So now petitions have to be individually verified. And again, it's raising costs, making it harder. In 2019, after voters approved the Voter Restoration Amendment, the Voting Rights Amendment, the legislature put in a very strict regulatory scheme for paid petition signature gatherers. They banned paying signature collectors, required paid circulators to register with the Secretary of State. They required paid circulators to file an affidavit with every petition. A lot of hefty fines and fees that could be issued for any late forms that are turned in or missed deadlines. The legislature also added a bold statement below a ballot initiative summary if it was estimated to increase costs, decrease revenues, or have a negative impact on the state or local economy, or indeterminate impact. And that played a role in this past election, as many of you all know. So in 2020, the legislature put in more strict regulations. So more than doubling the signature threshold to trigger Supreme Court review, requiring the Supreme Court to review initiatives for facial validity under the Constitution, creating a private right of action to challenge a petition circulator's registration. So any individual can sue, right? A whole bunch of other things here. Again, I'm just going to kind of move along in the interest of time here. In 2020, again, in response to the coronavirus pandemic, the Secretary of State issued an emergency rule that permitted electronic or remote signed signatures for candidate petitions, but not for initiative petitions. So again, we're playing by two separate rule books here. In 2021, the legislature passed SB 1890 that would have imposed a donation cap on people who wanted to donate to a citizen initiative committee. The ACLU of Florida ended up suing and got a permanent injunction on that law. So that law is not on the books. It is not in effect. And as we'll go over in just a couple seconds here, this year, the legislature passed House Bill 1205 that imposed very heavy restrictions on that citizen-led process. And so why did I go through this entire history lesson here, right? Promise you, I'm not a huge history nerd, although I like to play one on TV. But, a lot of times we talk about these restrictions on the process being put in the last few years, when in reality, this started decades ago, once politicians realized that this process is a threat to their power. And that's what a lot of this boils down to, is power. Folks may know in the 70s and 80s and half the 90s, the legislature was pretty much the exact opposite of where we are today, right? There was a supermajority Democratic majority. And so I'm not in the business of equivocating right now, but I do say this to highlight that this grassroots citizen-led process has puts the power to govern our lives and the policies that rule our lives in our hands. And elected officials and legislators do not like that. They see that as a threat to their power to propose policies. And so in the 2024 election, as we're still on the topic of state interference with citizen-led amendments, as we all know, we saw unprecedented interference from Governor Ron DeSantis' administration regarding Amendment 3 and Amendment 4. Those were the only two citizen-led amendments that were on the ballot out of 6 amendments. What else is there to say about last year's interference, right? We saw spending by state officials and state departments. The health department published a website that claimed Amendment 4 threatens women's safety, right? We saw investigators being sent to the homes of people who signed a petition just to make sure that they signed that this was actually their signature, right? Definitely not voter intimidation. They were just asking questions, right? Sarcasm. We saw the governor's administration threaten television stations for airing what was known as the Caroline ad for Amendment 4 with criminal charges. A letter that was signed by general counsel, by the department's general counsel, their lead lawyer, threatened to bring charges under a sanitary nuisance law that was mainly used for sewage, right? But claimed that the ad claims were threatening public health. Just a few days later, that same attorney resigned from his position, and in his resignation letter, he said, "A man is nothing without his conscience." So we saw some really heavy-handed moves that forced people in civil servants to impose one person's opinion on media. On that case of TV stations being threatened, U.S. District Judge Mark Walker ruled that the state's actions were viewpoint discrimination and suppression of protected speech. And one of his lines in there, Judge Walker always has some great lines in his opinions, but my favorite has to be this case. To keep it simple for the state of Florida, it's the First Amendment, stupid. So I loved it. And the federal, this was such an egregious overreach that the Federal Communications Commission, the FCC chair, put out a public statement saying that stations shouldn't be intimidated for airing political ads. She said the right of broadcasters to speak freely is rooted in the First Amendment, and threats to broadcast stations for airing content that conflicts with the government's views are dangerous and undermine the fundamental principle of free speech. We saw a bogus report that was put out by the Office of Election Crimes and Security, the Election Police Department that was formed by the governor in 2022, in October during early voting, putting out a report that alleged, thousands and thousands of instances of fraud related to Amendment 4 and questioned whether it should even be on the ballot. My favorite page on that report, and I use that term very loosely, was a chart that showed an analysis of 41 petitions in a county. 41 petitions, and they found a defect with 15 of them. And a defect can be anything so much as a faulty signature, maybe a very common one, as folks who have gathered petitions know. Some people write the country, USA, instead of the county, right? So they found a defect with 15 out of 41 petitions. So they said 31%, upwards of 31% of petitions could have a defect with them. And they ran with that to be representative of the over 900,000 petitions that were collected to put Amendment 4 on the ballot.
Wow.
And as we're learning now, there was also the laundering of Medicaid dollars, over approximately $10 million of Medicaid funds that were diverted to political committees through the Hope Florida Foundation. And that's still an ongoing saga. So in addition to that, this year, the legislature passed House Bill 1205. And this bill makes it nearly impossible, not impossible, but it really makes it harder for everyday Floridians to use the citizen-led amendment process, which again is a check that the people have on government that increasingly refuses to listen. So I like to call things what they are. This is a blatant power grab, and it's an attempt to silence the will of the people. It's not about protecting integrity of the process. It's about preserving power for those who are already in control. Because when politicians don't like the outcome of citizen amendments, they change the rules in the middle of the game. That's not democracy, that's manipulation. So House Bill 1205 does I categorize this bill in kind of a bucket of 3 different items. It creates financial and legal hurdles to the process. It makes petition gathering more expensive, and it criminalizes the process. So under that first category of hurdles, um, some of the provisions include invalidating signed petitions if they were collected by someone who wasn't properly registered as a petition circulator, regardless if the voter's signature was legitimate. So someone's legitimate signature can be invalidated through no fault of their own. Volunteers have to comply with the same registration and reporting requirements as paid petition circulators. So a volunteer, there's a caveat here, but volunteers would have to register with the state, complete a 2-hour online training, and include personal identifying information on each petition form that they collect. Now, I'll get to that. I'll get to the caveat to that in just a second here. But I wanted to finish this first bucket here. It adds the fiscal impact statement that we talked about to the petition form. And if the Florida Supreme Court rejects the fiscal impact statement for whatever reason, petition gathering has to start over from the beginning. And it's important to note that judicial review only starts once 25% of the valid signatures have been collected. So we're talking already hundreds of thousands of petitions that have to be starting from square one, basically. The second part here is that it makes petition gathering more expensive. So that was a running theme that we saw throughout those regulations over the years, and it continues here today. So it shortened the deadline that amendment sponsors have to submit a paid petition from 30 days to 10 days after it's collected. And as folks who have done petition gathering knows, that is very, very little time to do actual quality control. Make sure that there are no errors on the form and reach back out to the voter if there is an error. It imposes steep fines per petition if the petition is returned to the wrong county. Even if it's the county that the voter listed on the form, it has to be sent to the one that they're registered to vote in. So again, through no fault of a sponsor, they could be fined $500 per petition. And so when we're talking at the scale that's needed for a statewide campaign, that adds up very, very quickly. It bans certain people from being petition circulators with a $50,000 fine for every violation. And so, excuse me, so folks who gather petitions have to be a Florida resident, they have to be a US citizen, and if you have a felony conviction, you must have had your rights restored. And it also adds new requirements to the petition form that voters might not be comfortable writing on a form. So either the last 4 digits of your social security number or your driver's license. There's a lot of identity theft in Florida, especially. And so if someone walks up to you and says, hey, write on this piece of paper your last 4 digits of your social, I wouldn't blame someone for thinking twice, right? And adding a legal warning that signing a petition more than once is a misdemeanor crime. And then the third category here is criminalization. So this bill creates a 3rd-degree felony for anyone who collects more than 25 petitions if they're not a registered petition circulator, except for their own their own petition and for their immediate family petition. And immediate family is defined in statute.
But we've got 6 minutes left before the meeting is going to be over.
Absolutely.
Can you wrap it? And
yes,
we'll see if
yes,
we have
absolutely.
any questions.
So again, it imposes some limits there. And again, why are they proposing these changes? Because it's a threat to their power. So that was actually my last slide. If you would like to learn more, you can visit our website, aclufl.org. Follow us on all social media at ACLUFL. We're on Twitter, Facebook, Blue Sky, Instagram, TikTok, all that. So feel free to follow us and stay involved. Thank you. And now we'll move on to questions.
Okay, thank you. Any questions? Yes.
Thank you. That was most excellent. And thank you for putting it in the context of history. I think it is important to kind of weigh and evaluate our own reactions here. But my question has to do with, a path forward. Like if you could give us some directions on a path forward besides, waiting for it to play out in the court. I think that would be, helpful to sort of temper the doomsday
Right.
feelings that we're all having right now. Thank you.
Yeah, no, of course. And so I did, as I mentioned, this bill makes it a lot harder, but I will never say that something is impossible, right? Because history has shown that when highly motivated people organize and get together and really push for the change that they want to see in our state and our country and our communities, we can make it happen. And so I don't want to, be a doomsayer. I do think that there are ways that we can work through this process and still allow the people of Florida to make their voices heard. I can tell you from conversations I've had with folks who have run the statewide campaigns, they're already trying to game out the best and most feasible solutions for operating under this new framework, right? So, the final bill just passed yesterday, and so we didn't know a lot of the policy specifics there. But I will tell you all that those conversations have been ongoing for the last few weeks. And in fact, I was just the reason I'm not in town today is because I was in Las Vegas this week for a conference on ballot initiatives from a nationwide conference. And these kinds of bills are not unique to Florida. They're happening around the country in legislatures that are hostile to the freedom to vote and direct democracy. And so there's a lot of strategizing going on. Specifics, like I said, the bill was just finalized and signed yesterday, so I can't really give any actual specifics for navigating that framework, but I can tell you some of the best minds in Florida are getting together and doing their best to figure out, okay, this happened, it's going to be playing out in the courts. How do we move forward from here? What do we need to do to mitigate any legal risk, but at the same time be able to turn in petitions at the scale that's required in a timely manner? So those are going on, and I have confidence that best practices will be shared out once those are developed in full.
Thank you very much. And we do have to stop at this point, but I'm sure that we will stay in touch and we will bring news of any developments to you through our organizations here. And I'd like now to have Sandy make closing remarks.
Thank you, Gary. And yes, we will all stay in touch. We will be working on this throughout the next year. I'd like to thank Gary for keeping us on track and also calm, and Joe for explaining very clearly why we need this, and Abdullah for giving us a historical perspective and also hope for the future, because we do need to work on this. So I'd like to thank the speakers and thank all of you for your participation. I'd like you to know that we had almost twice as many people signed up as are here, so they will get the recording of this and we will post it, and we'll continue to have meetings on this and to share out information. I'd like to recognize Kathy Kozak, the Sanibel president, colleague, Sanibel League of Women Voters president, not a Sanibel of the league on Sanibel. And we are short on time, but please, all of you, register to vote, renew your vote by mail registration, sign up for league emails so we can keep you informed, and stay involved and make a difference. So thank you very much for participating today. And board members, at 11:15, we're going to have a short meeting, so please stay for that.